So something that Mr. Banerjee mentioned towards the end of his speech provides a good segue for me to begin mine, which is this very vexed issue of the idea of group unity, and when within the same group there might be a tension between the needs or the interests of the group and the interests of an individual. And that's basically going to be the crux of what I discuss. Now, if you look at the Indian Constitution, Part 3, and you ask yourself, what is the basic normative unit that the Constitution focuses upon? You'll find that there's no one answer. And Part 3 seems to be, as again Mr. Banerjee pointed out, a curious and sometimes unhappy mix between individuals as rights bearers and communities or groups as right bearers. That's one thing. And secondly, even the relationships that Part 3 establishes are of a diverse sort. So you, of course, have the classic understanding of a right, which is the individual against the state. Right? So Article 19(1), freedom of speech, and so on, are individual rights against the state. You also have individual rights enforceable against other individuals. So Article 15, Clause 2, for example, is a right of non-discrimination that is horizontally applicable between individuals. You have the rights of communities against the state, so the right of communities under Article 26 and other articles to manage their own affairs free from interference by the state. And all these issues have been considered, and the question of why this mix occurs in the Constitution is a contested one. So some scholars argue that throughout the 1920s, 30s, and 40s, there was this whole process of competitive communalism between communities, which finally led to a political compromise within the constitutional document. And there are other theories as well. But you can see, broadly, that the Constitution doesn't seem to categorically or specifically stipulate who rights bearers are. And when you have different rights bearers and different relationships of rights and obligations, then obviously tensions will arise in this context. And one tension that I want to address, and it's something that isn't discussed too frequently, at least in case law, although it is politically very controversial, is what happens, as I said earlier, when within the same group you have a conflict between the individual and the group. And I'd like to frame this issue by discussing a Supreme Court case, which I think will help us to think through the many difficulties that arise. This is a 1962 Supreme Court judgment. It's called, the full name is Sardar Sayyidina Tahir Saifuddin versus State of Bombay. If you Google it, you'll find the judgment. It's a constitution bench decision, 5 judges. There is a majority opinion, 3, a concurring opinion, and a dissent. And then that actually is good because it really helps to put the issues in perspective. Now, this case was about the power and the authority of the leader of the Dawoodi Bohras community to excommunicate members of the community. And before independence, the Privy Council had held that the Dai, or the chief of the Dawoodi Bohras, has the power under ancient custom to excommunicate any person that he feels is not adhering to the tenets of the religion. And soon after independence, the Bombay legislature passed a law whereby it prohibited excommunication, and it stated that excommunication which deprives an individual of legitimately enforceable civil rights, which includes the right to access to burial places, places of worship, the right to hold property owned by the community, and so on. Insofar as excommunication deprives an individual of exercising those rights, it is illegal. And that law was challenged before it came to the Supreme Court. And it was challenged on the twin grounds of Article 25(1) and 26(b). And 26, specifically important, it authorizes or it guarantees the right of religious denominations to manage their own affairs in matters of religion. And the Dawoodi Bohras claimed that they were a denomination, and that the Bombay excommunication law adversely affected their rights to manage their own affairs by prohibiting excommunication. And by a majority of 4-1, the Supreme Court accepted this claim and it struck down the Bombay Act. And what we'll discuss is the reasoning that was employed in the 3 different opinions and how these opinions differ with respect to the tension between the individual and the group that he or she claims allegiance to. Right? So the main argument that was made by the state defending the law was that although the decision to excommunicate an individual is a decision that's made by the religious head, taking into account considerations of religion, its effect is to deprive the individual who is excommunicated of many rights that are otherwise enforceable in a civil suit. In other words, although the decision might be taken on grounds of religious considerations, its effects or its impact stems far beyond the religious field. And so what the state is trying to do is to curtail the deleterious effects of excommunication that expand beyond simply religion. Right? And that was the argument that the state makes. The court, in rejecting this argument, says that it doesn't matter what the impact might be. The key question is that is this a religious decision? Right? Is there a decision based on religion, the decision to excommunicate? And it then goes into the history of various communities and groups and finds that excommunication has been an integral tool to hold the group together, to weed out dissenters from the group, and that groups can't survive unless there is this mechanism to discipline people who might go astray. And in doing so, it refers to precedents and holds that if a certain practice is essential to or an integral part of the religion, then even if it is a practice that is not simply a matter of worship or simply a matter of conscience or belief, that practice too will be protected. There is something called the essential practices or the integral parts of religion test, which many of you would have heard about. It was recently in the news when Rajasthan High Court banned Santhara and said that it's not an integral part of Jainism. And so the majority holds this. In his concurring opinion, Justice Iyengar is even more clear about this, because one of the arguments made by the state again was that this Excommunication Act is a step towards social reform, which Article 25 allows the state to do. And what Justice Iyengar holds is that, well, yes, you do have a right to undertake social reform, but you can't reform a religion out of existence. And so if, to the extent that your reform law would affect the integral part of the essential practices of religion, then that is not allowed to the state. So Justice Iyengar, in his concurring opinion, much more clearly than the majority, actually holds that essential practices or integral parts of religion are walled off against the state's attempts at social reform. So there are 2 ideas that I'd like you to keep in mind. One is the idea that every group must have certain mechanisms to discipline dissenters and to hold the group together. And secondly, that insofar as a practice is deemed to be an essential part of a religion, then the social reform exception does not apply. Right? And these 2 ideas you find in these judgments. Now I'd like to step back for a minute and I'd like to ask, where does this idea of essential religious practices come from? Because it's not there in the constitutional text. Right? And so far it isn't there in the text at all. It's a doctrine that the judges have come up with. And then obviously, to be legitimate, it must have some kind of a foundation in constitutional history or tradition or the structure of the Constitution. And if you go back and actually ask yourselves where this phrase has come from, it's quite interesting. The phrase is used by Ambedkar in the Constitutional Assembly debates, but in a very different context. And it's worth reading out what Ambedkar said. So on the 2nd of December 1948, he delivers a speech where he says that the religious conceptions in this country are so vast that they cover every aspect of life, from birth to death. There is nothing which is not religion, and if personal law is to be saved, I am sure that in social matters, we will come to a standstill. I do not think it's possible to accept a position of that sort. There is nothing extraordinary in saying that we ought to strive hereafter to limit the definition of religion in such a manner that we will not extend beyond beliefs and rituals as may be connected with ceremonials which are essentially religious. Right? So that's where you see the words essential and religious being used together. But if you think about it, he's not using it in the same way as the court used it in Sardar Saifuddin. What he is drawing a distinction is between practices that are essentially religious, in other words, whose character is religious, and practices that are non-religious but could be attempted to be justified under the garb of religion by trying to expand the meaning of religion so as to include tenancy, property, and things like that. Right? So Ambedkar is trying to guard against that threat. That because in India, according to him, religion tends to cover a much broader swathe than it does abroad or in the West. Therefore, we must inquire whether the practice is actually of a religious nature and then decide upon one protection. Now, in the court's early cases, this was actually the understanding that was followed. Right? So, in Lakshmindra Swamiyar's case and in Ratilal's case, which you would have read about in constitutional law, when it came to the question of whether giving food to the deity at certain times of the day and so on, were these religious practices, the court actually asked the question that, are they actually of a religious nature, and then decides upon protection. But then in this case called Ram Prasad versus State of UP, a High Court case, for the first time, to the best of my knowledge, subject to correction, you have a subtle shift in the test. That case was about whether prohibition of bigamy is unconstitutional because it violates religious rights. And in that case, the court goes into the Hindu religion and says that, well, actually, bigamy is not an essential practice of Hinduism. And you can see what the shift is here. The term essential has gone from qualifying the nature of the practice, that is, whether something is essentially religious, to its place, the practice's place within the religion, which means is it essential to the religion. Right? So from whether it is essentially religious to whether it is essential to the religion is the shift the court makes. Right? And so it transforms the whole test from adjudicating upon the nature of the practice to its place within the religion. Right? And so it transforms that. And a few years later in the Qureshi case, again the Supreme Court adopts that by saying that slaughtering a cow on one Bakrid is not an essential part of Islam, and that crystallizes the shift in what the test is about. Right? So when the Supreme Court in Saifuddin, the majority, uses the essential practices test to invalidate the Excommunication Act, it's effectively operating upon a totally different conception of the meaning of the words essential and religious than what was at least the intention of Ambedkar. Right? And that, of course, allows the court to then become an arbiter of what religion requires, and that's been criticized on a number of occasions when you go into that. Right? On the other hand, right, Justice Sinha's dissent actually exemplifies what Ambedkar originally considered, and engaging with his dissent actually helps us to also understand how we might adjudicate or mediate the tension that arises in cases like this, where the individual's right to conscience and the individual's freedom to dissent, it comes into conflict with the group's claim to maintain its own affairs in religion. Right? And so Justice Sinha, his test is that insofar as a religious practice or a practice that is claimed to be protected by the Religious Rights Clause, insofar as that affects an individual's civil rights, which was the claim by the state, to that extent, the state can regulate that. And in this case, he finds that excommunication, its impact is precisely that a person can no longer access the traditional burial sites of his community, a person can no longer access places of worship, a person cannot hold certain kinds of property, and so on. And he finds that all of these aspects are essentially rights that can be enforced by a civil suit, and therefore they go beyond the realm of purely religious and become practices that can be are civil, and therefore the state can protect them by curtailing the right of the group. But what's even more interesting is the overall philosophical justification that Justice Sinha gives. And so the framework that he places upon the judgment is that this is about protecting the individual's right to dignity. Right? And that he begins with that. He then goes on into his analysis of the judgment and why the act is constitutional. And he ends by saying that what we are the mischief we are trying to prevent is he's trying to prevent the individual from being treated like a pariah in his own community. And he draws a link between Article 17, the untouchability provision, and says that, look, even though the decision might be made on religious grounds, the decision might be made by the religious head, ultimately excommunication, the effect that it has is that you become completely estranged from your community. Right? And so the impact upon you goes far beyond simply not being allowed to participate in the group's religious life. It goes far beyond, it goes into the social and economic domains as well. And this, you can see, speaks back to Ambedkar's concern that in a country where the scope of religion is so vast that it ends up covering not just what we think of classically as religion, but ends up covering your entire life from cradle to the grave, including your social and economic interactions with your community. In that case, then, we have to think about how we can best mediate the connection, the tension between individuals and groups. And the way of doing that is to actually have a test which stops the authority of the group at the point at which the individual's civil rights, the individual's dignity, and the individual's ability to live within the community as an equal member is jeopardized. And that's his framework. And I'd like to end by just linking this with the overall theme of this conference, which is law and liberty. Why is it that a constitution protects group rights? Now, this is a very controversial question. There are many different arguments for and against. One set of arguments would hold that a community is in itself an entity, that is a rights bearer. There's something that is normatively attractive or good or just about taking the community as your unit, as it is the family or anything of that sort. That's one line of thought. The other line of thought is that the reason why we need community rights is because often individuals can only realize their full potential and can only exercise their freedom in a meaningful way through the community. Right? And so, according to this line of argument, which is a more liberal, a more individual-centric argument, we need communities of a certain sort to advance the cause of individual freedom. And to the extent that communities are required for individuals to exercise their rights and be free in a meaningful sense, we protect them as well. But obviously, this protection would then stop at the point at which the community's dictates begin to substantially interfere with the individual's freedom. Right? And that effectively is what Justice Sinha said. Right? And so if we understand the Constitution and Part 3 as being about the individual and protecting individual rights, and we understand the community rights, the group rights provisions as being furthering this end and not in conflict with them, then we would try and devise a test where we reconcile the individual and the group from the overall perspective of individual freedom. Right? And that is something which is not presently part of the court's doctrine. There is the judgment in the Dawoodi Bohras case has been, it's up for review if I understand, and notice has been issued, but it's still up for hearing. So it is to be hoped that when the Supreme Court, if the Supreme Court does decide to, in the near future, hear this case again, it will hopefully go back upon its judgment and devise a doctrine that more adequately respects individual freedom. Thank you.